For that introduction, and thank you, Olga, for this event. It's actually the academic conference you've had today, was it, and yesterday as well?
Yes.
I think we met sort of 4 years ago on a predecessor conference, so I can only imagine if there's anyone here who was on that earlier today. I'm sure the discussions were as lively as they were 4 years ago. So hi, I'm Sarah. I work for the International Committee of the Red Cross. I'm not a lawyer. I want to say that very clearly straight away, but I'm very glad to sort of try and put forward the ICRC's view on women in international humanitarian law. Why ICRC and why international humanitarian law? For us, we're really an operational organisation. We work in 80 countries around the world. We have 15,000 staff, and we have key operations in conflict zones such as Syria, Yemen, South Sudan, Iraq. And it's really responding to the needs of people on the ground that's our priority. Why international humanitarian law? It's the body of law which governs how states and armed forces and armed groups should behave in conflict, and that's extremely important. And for us, it allows us, it gives us a framework within which we can respond to the needs of people, and that people can be protected. So I'm going to go through these slides, but I'm going to be relatively quick because they're quite legal, but then hopefully give you some sort of thoughts on gender and IHL and our programs after I've gone through them. So if I can work this. Excellent. I've sort of explained a little bit, sort of very briefly, about international humanitarian law. It provides this body which is provides protections for people involved. Why have a gender perspective on it? Armed conflict affects women, men, boys, and girls differently, and it can often exacerbate pre-existing inequalities. I think for an operational organisation and for those who are trying to understand the law on the ground, it's important to recognise different experiences. We cannot assume that stereotypes of women only as mothers or caregivers or men only as fighters are true, and I think that is extremely important when it comes to making the right decisions about how you target, how you understand what is acceptable actions in conflict, but it's also imperative when you're trying to provide an effective response. So that's a really sort of a key element for us. I think there's also, I'm not going to go through all the words on the slide, but I also want to just pick up the bit at the bottom about an intersectional approach. And for the ICRC, it's important not just to think about gender, but also to think about race, class, ethnicity, disability, nationality, religion, migrant status, and sexual orientation. There are probably others that aren't listed there. And again, to think about it from the perspective of an operational organisation, it's important to think about these things, because if we don't understand what's happening, if we don't understand the people who we're trying to help, we can't actually provide services and make sure that we're accessing those who we need to. So yeah, that's our sort of kind of a gender perspective on IHL. On women in particular, there are certain elements of international humanitarian law, the law of armed conflict, where there is a specific provision for women. So generally, women are members of the civilian community or combatants and fighters, and they are therefore entitled to not be discriminated against. So an example of this may be the unfair treatment of a woman who is a combatant and let's say who is pregnant, who will be subject to specific protections and may be treated unequally as a result of or not given the proper protection she deserves as a result of her sex. So it's an extremely important area. Then there's special protection. So pregnant women and mothers, as I've just given that example, maternity cases went during evacuation, hospital and safety zones need to protect expectant mothers and mothers of children under 7. There are these key rules which are written into this law. And I must say that they're just on international humanitarian law. The main texts are relatively old. 1949 is when the Geneva Conventions were written, and their additional protocols followed more recently. But they do not always refer to women in a way that we would do now. But there are still areas where there is extremely relevant that those protections still exist and can be applied. Women who are detained during an armed conflict also have a specific protections underneath the law. So men and women have to be separated. Disciplinary measures should take into account sex, and there should be immediate supervision of women detainees by female guards. So onto sexual violence. There's an absolute prohibition of sexual violence in conflict. Yet we know that it occurs against women, men, boys and girls across the world today, as it has done, sadly, for as long as we know in conflict. It's not limited to physical violence, but there are many forms of sexual violence in conflict, and all are explicitly illegal and prohibited. And I just wanted to put this extremely legal slide up there just to show how thorough it is, that prohibition. But we know that sexual violence is prevalent and widespread, and I want to sort of shift back into talking as an operational organisation. For us, we have recently released a new strategy to try to combat the challenge of sexual violence in conflict. And for us, there are three areas that are really key: access to necessary services, that we need to strengthen the resilience of individuals and communities who have sadly faced this reality, and that we help to prevent future instances. And that prevention work often involves directly talking to weapons bearers, to armed forces, to governments, to authorities, to help them to ensure that the body of the law is included in their rules of engagement, in their policies, in their local doctrines, codes of conduct. It doesn't matter what names they're given, but this must be included. And when sexual violence does occur as part of an activity of someone who's controlled by an authority, i.e. not interpersonal violence, then it's absolutely essential that there is accountability and justice and punishment for those who have done that. And it's through these three areas that we have the goal to support the elimination of sexual violence in conflict, other situations of violence, and detention. And it's worth perhaps just quickly pointing out that detention is a specific scenario where those detained are at a special risk and there is a real vulnerability, and that's something that we in particular focus on. We also want to, in our response, it's important that we understand that sexual violence does occur against men, women, boys, and girls. However, that does not exclude it from being a gendered practice. It's linked to and arises from harmful social practices based on perceptions of gender and power dynamics. It is not separate from them, and our response has to factor that in, and that's something that's extremely important in trying to understand motives for why sexual violence happens. So, for example, in a community, men may be seen as and often seen as leaders, as the protectors of a group, and if it's them that are targeted with sexual violence, there may be a real intention to bring to its knees a community, to really underlie that strength that those men would ordinarily give it. Equally, the ways in which sexual violence is executed is also often connected to gender understandings. So an example here may be forcing detainees to strip and parade in front of guards of the opposite sex, of trying to really break down those relationships between communities and individuals. And then also we can see that the vulnerability to sexual violence in conflict is gendered. So an example of this may be members of the LGBTI community who are particularly targeted because of understandings of gender norms which are seemingly transgressed by the identities of those individuals. And then just finally, I want to quickly talk about some of our operations. So I mentioned that we work in quite a large number of contexts around the world. In particular, a number of years ago, we noticed that because sexual violence in conflict it often is an invisible crime. It's not something that is obvious. It's often stigmatized. There is the tendency to blame the survivor or the victim rather than the perpetrator. And all this has led to it being traditionally quite difficult for humanitarian organizations to conduct what would we would understand as a needs assessment on any other subject matter. So we have done what we call reverse the burden of proof. We've made it clear that our operations need to search this out, need to look for cases of sexual violence rather than expect them to come to us. So that's been a huge part of how we've expanded our programs in this area. And we, for a long time, have had significant responses to the needs of those affected by sexual violence in Democratic Republic of Congo, Colombia, and more recently, Central African Republic, Mali, Nigeria, South Sudan, and Mexico. But that's just listing a few, and I just want to say that there's now 40, as of beginning of this year, there were 44 countries in which we conducted programs in as many as possible in a multidisciplinary way, looking at more than one aspect of support to those affected, more than one way of trying to prevent this from happening in each context. So it's an extremely important part of our work, and I think that linking this back to the law, the fact that this is illegal, the fact that the sexual violence is absolutely prohibited in times of peace and war, because I have just been talking about international humanitarian law, but of course this is illegal under human rights law. It gives us a basis for action. It gives us a clear narrative within which we can engage with communities. But it's not the extent of it, and I think we all can understand that sexual violence goes against every moral code there may be, and that is also an extremely important way in which we can reach out.